Welcome to the Napa Legal Podcast. I'm Mary Margaret Bush, Napa Legal's Executive Director.
And I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. This week, we'll be covering Georgia's passage of a state religious freedom restoration act, which I believe makes them the 30th state in the union to pass one. We'll be going over an effort by the governor of Oklahoma to review laws that restrict religious liberty. I'm really excited about that one. And then we'll close with the IRS's recent decision to drop an investigation into a church regarding political activity.
Great. So we'll start off strong this week with one of our favorite topics to cover, a State Religious Freedom Restoration Act. So, just as a refresher, as we discussed in past episodes, Religious Freedom Restoration Acts don't mean that religion always wins, but they do mean that the government must be accountable when they enact laws or regulations or take other action that restricts religious freedom. So let's look specifically at the Georgia Religious Freedom Restoration Act. It follows the typical structure, and in fact, in the preamble, the Georgia text actually ties their RFRA to the federal RFRA and says this does in Georgia what the federal RFRA does at the national level. So it follows the typical structure, statement of purpose, form of relief, and then a section on construction of the statute. So we have the usual text that when the government enacts a law that burdens religion, it can only do so if it is the least restrictive means of or furthering a compelling government interest. So, how does this specific text compare to some other state RFRAs? I'd say this is pretty much right down the middle. It's more inclusive than those we've seen in like Indiana and Pennsylvania, where they're either requiring less than strict scrutiny or they're limiting the application of the statute to certain types of burdens. It's a little less comprehensive as some others we've seen. For example, Wyoming, where there's potentially a little bit more relief available, or Utah, where private parties are incorporated at some level into the structure of the statute. But one thing I really liked is in the at the opening of the statute, it describes religious freedom as an inalienable right, and I've just been reflecting a lot lately on just recovering that word and remembering what it means. Inalienable means that it's not a right bestowed by the government. It's not a right minted or created. It's a right that human beings have because we are human. It's part of human dignity. And so um, the RFRA really sets itself up in that sense as restoring the natural order, which is the right to religious freedom, rather than bestowing it. And I think that's a really important framework to use when we think about religious freedom in general, and that these laws aren't granting privileges from the government. These laws are just recognizing the reality that it is not the place of the civil government to limit people's ability to worship their creator. So I think it has strong philosophical underpinnings, a good introduction, and then I think the ties to the federal government are interesting. It doesn't incorporate it by reference the way, so it's not really full lockstepping, but it definitely says here's in terms of a statement of intent, it says what we're trying to do here is in the same spirit as the federal law on this point. So I think it's a very strong RFRA, and also it's just great to see the 30th state enacting these after a little bit of a desert, seeing these pick back up. So yeah, Frank, I know you and I have gone back and forth a lot about state RFRAs. What are your thoughts on this one specifically?
Yeah, I mean, first of all, just this is great. It's we like to maybe overstate our importance, but I would say that since Napa Legal started the Faith and Freedom Index, right, our study of these religious freedom issues at the state level, which was only 2 years ago that we released the first one, there have been, I think, five RFRAs. Right, I want to say Nebraska, Iowa, Wyoming, Utah, and now this one, at least five. Um, so it's great to see that there's this resurgence of focus on state law and protecting religious liberty at this level rather than relying on federal statutes and Supreme Court cases. So it's just great to see the train keep moving. And there are a few other states where I think it is politically quite possible to see RFRAs passed in the next couple of years. And so I'm hoping that we'll see that and we'll have more to cover. The one thing that I'll just dwell on for a quick moment, because we've talked about this internally at Napa Legal, but one thing that we would really like to see a movement on, and it's the one real complaint I have about this RFRA and most state RFRAs, right, is the limiting factor that let me use the language. So in the first section of the new RFRA in Georgia, subsection C, right, a person whose religious exercise has been burdened in violation of this chapter may assert the violation as a claim or a defense in a judicial proceeding and obtain appropriate relief against government. So that qualification that the government be a party for a RFRA action, it does limit the ability to use it in certain cases. I won't go into too much detail. We've talked about this before. Like there was the Liberty University case that we covered a few weeks ago, right? Where one of the many claims that was thrown by Liberty was a RFRA claim, saying that enforcement of the Civil Rights Act, non-discrimination law as applied to them, violated federal RFRA. And the judge, I think, rightly said, "Well, makes sense, but the government's not a party, right? It's it's the aggrieved former employee versus the employer. There's no government party. I can't have a RFRA claim here." And again, I think that's a problem, but I think the judge was right. And the states that follow suit, I think you have the same problem where on one hand, it is at the end of the day government action that is violating religious liberty, right? It's the passage of a non-discrimination law or of the Civil Rights Act in the Liberty case. But if the government's not actually a party, even though it's government action that's affecting them, there's no real relief under RFRA. So I would like to see a little more attention paid to that. Again, I don't think this was like a conscious effort to limit the RFRA. I think this is just the way it's been done. And until a few states in recent years have caught on and have expanded and made clear that even when the government is not a party, you can still use RFRA claims or RFRA defenses. It just wasn't. I don't think it was really on the radar. So I'd like to see more of that. But in the meantime, it's very heartening to see that yeah, now 30 states, so by far a majority of states in this country now have RFRAs. It's great. All right, so we will move on to the second issue we want to talk about today. And this one's really exciting. I'll try to keep myself tight here, but there's a lot to say, I think. 'Cause I think this sets a real example, and there's a lot of really interesting material to cover here. So Oklahoma, the governor of Oklahoma, Kevin Stitt, recently published an executive order that was it. There's just so much here. So the backdrop for probably everybody who listens to this is at some level following the St. Isidore virtual Catholic charter school case in Oklahoma. But the backdrop there was really important, right? Kevin Stitt, the governor of Oklahoma, was very much in favor of St. Isidore being given charter school status, despite its explicitly religious, or maybe because of its explicitly religious character. And the Attorney General of Oklahoma currently is not in agreement. Although they're both Republicans, the same party in the state, but very sharp disagreements. The Attorney General was very clear that his opinion was that giving a Catholic school charter school status violates the Establishment Clause as well as some Oklahoma laws. And so this fight has been ongoing in Oklahoma for a couple of years within the party, within a one party government. Essentially, it was very interesting in that regard. And that fight, I think it's pretty clear by this executive order. That fight between the Attorney General and the governor is kind of the backdrop to why the governor signed this executive order. But and I so let me just go through what's happening here. So what it basically is, it's an executive order with some kind of preliminary information about, America being founded on principles of faith and religious liberty, the backdrop of the First Amendment, Oklahoma's unique place in the American heartland and its tradition of honoring faith and religion. So the governor is kind of laying this backdrop of this is why religious liberty is so important. But then there's a really solid technical reason for what he does, which is going to be a pretty broad order ordering all government agencies within Oklahoma to review any regulations or policies that violate religious liberty. So it's the structure of the order is really good. But first, I think this backdrop in the preamble clause is really good. So I want to read from it. So the governor says, whereas recent decisions of the United States Supreme Court, and he cites Trinity Lutheran, he cites Espinoza, and he cites Carson v. Macon, have reaffirmed that states may not exclude individuals or entities from public programs or benefits simply because of their religious character or beliefs. And whereas the Supreme Court has recognized that such exclusions are a violation of the First Amendment's free exercise clause, which ensures that faith based organizations and individuals can participate fully in public life without discrimination or penalty. Now, I thought that's worth reading in full because this is not a stunt by a red state governor, right? To say like, look, we want to look like a really like conservative religious state. Now, this is a really well thought out order, and I read through the whole thing carefully to prep for this, and I was just so impressed with it. So he's offering a technical basis. This isn't just I want to protect religious liberty. He's saying no. If you look at Supreme Court decisions over the past decade, a lot of the state laws that exclude religious organizations and religious individuals from government funded programs are clearly in violation of the free exercise clause of the First Amendment, right? It was hinted at in Trinity Lutheran, strengthened in Espinoza. Now the fact that Carson v. Macon, that's just, makes it obvious, right? That if you just can't do it, you can't have a publicly available funded program and say, okay, all schools can come and take money from this program. Oh, except if you're religious. Like you're clearly discriminating solely on the basis of the religious exercise of that school, right? Their identity and their practice. So I really like that. There's a good basis here saying, look, we have a lot of laws in our state that violate the First Amendment or probably do. Um, and then he goes on and says, Oklahoma has taken steps to improve religious freedom in response to these cases, especially. Then he points out that in 2023, the state amended its RFRA to prohibit excluding religious entities from government-funded programs, which I think was a response to Carson v. Macon, which had just been decided the term before that law was passed. But then the governor says there are still legal barriers that make Oklahoma law inconsistent with First Amendment precedent. And he points out some specific ones. He actually points out the Oklahoma Attorney General and his apparent hostility to religious liberty. So clearly there's some political animus, right, going on here. Um, so he lays the groundwork. I think it's really well done. But then he points out what exactly he is ordering and encouraging to be done. And I think this is really good. So I'm going to spend a couple minutes here. So the actual meat of the executive order, the three main things. One, the governor requires that all state agencies review any regulations, policies, practices, and that exclude religious entities or burden-free exercise, and that they submit a report to the governor. Um, and then the governor, by name, identifies a handful of statutes that need to be reviewed and directs the appropriate agencies to suspend enforcement of them pending this review. And so he points to, again, I think he's all on solid ground here. These are all in response to the line of cases that we mentioned. So he points to a statute that prohibits the use of state art funds to aid religious entities. There's a historical preservation fund prohibited from religious entities. Um, Most of them are like that. Land proceeds can't be given to religious schools. There's the charter school requirement that they be entirely non-sectarian in their operations. There's another art grant that's in the regulatory code. So I think it's pretty bold, but it's also great to see that it's not like a pie in the sky. Here are our principles, and we have to make sure that our laws are not violating, Carson v. Macon and the First Amendment. But then he goes down to, listen, these 7 laws likely do violate the First Amendment, and I want them examined. I don't want them enforced by my executive agencies in the meantime. And then what he does finally is he encourages the legislature to take a look at and repeal several or redraft several of these statutory provisions. So, Mary Margaret, I'd love to hear what you think. I'll just say I love this. I think this is such a great example of how a federalist republic ought to govern and ought to work. Right? We have federal and state law. We have separate branches of government. It's often very tense how those overlappings work. Right? So I think the governor here, I think he just did such a good job. He identifies a fundamental problem, laws that interfere with religious liberty at the state level, and a basis for opposing it. Right? First Amendment precedent. Then he uses his authority properly, right? He identifies places where the supreme law of the land, right, the federal constitution conflicts with state law, and then he orders action. Where he has authority is over his executive agencies, right? So he orders non-enforcement, he orders reports to be made, he orders that regulations be changed. This is all proper because he's ordering executive agencies who are under his direct control. And then he encourages legislators follow suit. Take a look at these statutes. I think these probably don't comply with the First Amendment, but I think it's brilliant, right? He knows where his lane is. He knows where he has to comply with higher law. He knows which agencies and branches of government are under his control and which are not, and where he has to encourage the other branch of government to follow suit, right? So I know I've gone on a lot here, so I'll stop and give it to you, Mary Margaret, for your thoughts. But I was so heartened by this. I think this is such a good example of leadership at the state level.
Yes, Frank, I think that's exactly right. I think one of the things that's most encouraging about this isn't just what was done, but the way in which it was done. I've been hearing the theme over and over about polarization, and there's even, some thought about, oh, is the left was kind of polarized. There's some talk of like, is the right becoming polarized? And I think something like this, where it's advancing a policy that's faithful to the founding principles in a way that's so so conscientiously consistent with the rule of law. I think that's a model for any kind of legislation or any kind of government action. But it's particularly heartening to see religious freedom and the rule of law being kind of linked together by a state leader in order to make to restore to Oklahoma the inalienable right of religious freedom, and just to make sure do these periodic checks to make sure that in the vast amount of legislation that's passed that these founding principles are not being forgotten. And I hope that this is and I think that it is indicative of a state law religious freedom movement. I think this is one of the early instances, but I think we really are seeing momentum for a state religious freedom revolution, just a return to the fact that state state priority docket, state policy agendas need to include religious freedom at the state level, and building that into the state culture and the laws and the regulations, and recognizing that government officials, governors should be at the head of this, but all officials should be aware of it, because I think too long this hasn't been publicly prioritized at the state level, and I think that's why we see large and small infringements coming from from the states. So I think this is both the way it was done, what was done, and kind of how it fits into the larger religious liberty landscape is all extremely encouraging. And I hope we continue to see. I think in our notes here we just have I hope that this is that it fuels positive competition with other states. And I think this really does offer a model for that.
That's a great point. And I'll say we've talked on this podcast and elsewhere in our resources about how we would love to see, and our friend Ian Spire has also done a lot on this. He wrote a piece called Toward a Religious Delaware, which is very good. Basically saying that what Delaware did to be corporation friendly, right, by amending all their laws and making them like a corporate haven, some state ought to become the religious version of Delaware and become the spot for religious liberty and religious organizations to thrive. And if I had to put my money on a place where there's a good environment and a good government for it, Oklahoma is has some potential for that. So we'll be closely following these developments in Oklahoma, especially the St. Isidore case as the Supreme Court weighs in. But with that, we'll kind of sadly leave Oklahoma and head to the IRS for our last topic.
Yes, this ends, I think, a relatively positive podcast on a relatively positive note here. So we had a good ending, but a little bit of a discouraging path towards there. So many people may be familiar with something called the Johnson Amendment. It was adopted in 1954, and it fits into the tax code, and it forbids religious tax exempt organizations from participating in political campaign activity. So there's been a lot of talk over the years about whether this is constitutional. It's questionable, I would say. Um, so we're kind of going to look today at how things are and how they should be. So how they should be, there's a lot of concern, and in fact, there's I think like a Freedom Sunday where pastors kind of intentionally violate the Johnson Amendment in order to declare publicly that they still have their First Amendment freedoms, and speaking on a candidate's fitness for office from a religious perspective is um you know, it's something that is very strange to have that silenced, I think, or to have sort of that. And I understand that the tax implications are there. You know, we can't have 501(c)(3s campaigning, but I think there's a better way to go about setting those guardrails than this. But yet the law is still on the books. And so New Way Christian Church in Florida had a candidate, I believe it was for local government, speak at the church, and the pastor prayed over her. And they thereafter received a letter from the IRS with a series of questions asking, did the church, in any way time this, or had they invited both candidates? Some questions along those lines, basically ascertaining whether the church had violated the Johnson Amendment such that the church's exempt status might be in jeopardy. It's kind of interesting timing wise, just as a side note, my dad actually sent me an article that it's just come out recently that some of the people from the lowest learner tax regime that had wrongly repressed applications from religious or conservative groups and back I want to say it was around a decade ago, maybe a little longer, that their news came out that some officials from that regime were still holding influential offices within the IRS. So it goes to show you that the deep state is real, and that it's quite possible that there may be some animus towards religion continuing to lurk over there. Um, so in any case, this letter came to the church. The church engaged counsel with First Liberty. First Liberty represented them, engaged in back and forth letters with the IRS, and on March 21st, the IRS dropped the investigation. So you definitely see there's a chilling effect here. It's quite scary, especially when you're a conscientious organization. You want to do the right thing, and I think particularly religious organizations with a moral code um, are loath to flaunt the law, which is good. And so I think this was a damaging thing for the church to go through. Um, there are a couple things I think to consider here. So did this church come kind of close to the line with respect to the Johnson Amendment, based on the fact patterns that I read in the coverage? It's they certainly kind of came close to the line. They did have an active candidate for office at the church. Some of the boundaries around that are, you can't churches really can't name names during campaign season. They can't if they invite a candidate to speak, they need to invite both candidates. So if there are three, they all need to be invited. Whatever, it can't just be a particular candidate. But if only one candidate accepts, they can still proceed with the programming. So those are some of the don'ts around these issues. But what are some of the do's? Because I think at this moment, communities of faith are, I think, really America's last best hope for cultural restoration. Every other institution has really fallen short in a very prominent way in the last decade. So what can churches do to try to bring wisdom without running afoul of the law as it currently is? Um, well, issue advocacy is always acceptable. And one thing I think is important about it is from a tax perspective, consistent issue advocacy is even more defensible than one-off issue advocacy. So if the church is consistently saying, here's what we believe and here's why and here's what those implications are for the culture, for the community around us, and what our idea of the common good looks like, if they're doing that consistently, it will be much more defensible for them to do that during election season when saying a particular issue, saying that a particular issue is very, outcome determinative or should be for that church community. During election season, that can be a bit risky, I guess, because the IRS could say, well, you've never mentioned this before, and now you're mentioning it. And it's sort of like saying, who, everyone's reading between the lines. And so consistent issue advocacy is important. And in fact, from a risk management perspective, more is more. And then I think the second thing is to really focus on those issues and educate the church community so that when it is campaign season, they don't really need a church leader to spell out, who's the one who best matches it. They've kind of, as a community, identified this is what we believe and this is what that's going to look like from a policy standpoint. And then finally, certain types of voter guides are permissible. So we have a white paper in the Napa Legal All Access website that just talks a little bit more about how an organization can engage in important questions about civil life without running afoul of the Johnson Amendment. And the USCCB also has some great resources on this. So in short, I hope that this doesn't have a chilling effect for organizations. And on the longer term, I think some reflection on the Johnson Amendment would be appropriate. So yeah, I know you probably have thoughts along this too, Frank, this kind of cocktail of First Amendment issues that all kind of came to a head in this case.
Yeah, I always have trouble with this because on one hand, I get that C3s obviously are cordoned off as not political, like campaigning organizations. So I get having some guardrails, but it is troubling when you're talking about a church who has clearly the members and the organization, the hierarchy have First Amendment rights, and clearly religious beliefs filter into political beliefs, especially with certain campaigns and certain candidates. It's going to be obvious that a church or a denomination is going to support or has to support one candidate and not another when issues become so severe on the types of issues that religion tends to care about, right? So it's hard. I'm not going to try to solve that here, but one thing I'll just say is I know anecdotally I've had this kind of tension in my own church community and political community in my local area here, where we've had more than once, political candidates who some of whom are friends of mine and who I support personally, and so does like the entire church congregation, right? So this has come up before. The candidate or members of the church want to invite the candidate to come and speak, in the church basement, or to do something like that. And obviously, I'm a lawyer involved in these things, so I don't want the church to get in trouble, and I don't think it's worth it. But it's hard, right? Because like you had said, Mary Margaret, the idea that, well, if you invite one candidate, you have to invite them all. It's like, I mean, in like one case that I'm thinking of, I had a friend running for office who's, a deacon in his church. He's, completely aligned on all the Christian values. And the opponent on the other side was just like antithetical to every issue that religious people care about. So it's like, well, no, of course we're not going to invite the other candidate to come speak at the church. That was never going to happen. So what do you do? I mean, first of all, you're right. I think the Johnson Amendment needs to get looked at. I think there's still some work to be done on finding this line between the tax code and the First Amendment. But in the meantime, honestly, just separate the church itself from the event and carry on. Like, the safer ways to do this is like, yeah. So in our case, there's a candidate who church members really wanted to hear speak. So you just disaffiliate it from the church. So I've more than once have had candidates just come to my backyard, right? And you have food and you have drinks and you invite everybody from the parish community, but it's not a church event. It's not being sponsored by the church, not on church property. The priests aren't there in our case, although they could be. So I think that's one thing I would say, is that while I don't think we should have to tread quite this carefully, in the meantime, I think there are pretty easy ways to tread carefully and just kind of keep the church out of it while still getting the church members involved. So that's one thing. And the other thing I would just mention is that, for one, you're right. Timothy Noonan's white paper on an intro to issue advocacy and campaign activity is great. And also, Napa Legal published, I think sometime last year, lobbying, issue advocacy, and campaign activity, an overview, and it also has a sample policy for religious organizations and churches that might want to have some guardrails onto the do's and don'ts that you described when you were just speaking. So that's also a great one. That's behind the all access paywall. So if you are an attorney working with nonprofits, or if you are a nonprofit leader listening to these things, there are some great resources within Napa Legal's library that can help you with these kind of thorny issues. All right. Well, with that, thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we'd appreciate it, as always, if you like this podcast and subscribe to our channel on YouTube, Spotify, or wherever you're listening. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty in general and the work of faith-based nonprofit organizations in particular.
We'll talk to you all next week. Thank you for your time and God bless.